Hi, my name is Maarten Buyl, and I will present a paper on tackling algorithmic disability discrimination in the hiring process. For this, we provide an ethical, legal, and technical analysis. Now, the problem of algorithmic bias is widely discussed, especially at this conference. We use algorithmic bias to refer to the unjust discriminatory manner in which automated decisions impact a certain protected group, or members of a certain protected group. This discrimination can, for example, be caused by a faulty design of AI architecture or a historical bias rooted in society and perpetuated by statistical inferences. Consequently, algorithmic bias is in many ways a perpetuation of human bias. In particular, we consider automated hiring systems, such as tools for screening resumes or for analyzing job interviews. While they have already been studied and even audited in the past, we noticed that the risk of discrimination against people with disabilities was underlooked, which provided motivation for our analysis. Furthermore, in all three areas of ethics, law, and computer science, there are some specific issues that make the condition of job seekers with disabilities deserving of further research. As a first step in our analysis, we looked at the ethical implications of hiring with algorithms. Based on prior research, people with disabilities experience a distinct type of discrimination that has several unique characteristics. For one, people with disabilities are systematically separated and segregated. With well-intentioned aids of separate entries, buses, bathrooms, etc., we involuntarily ban people with disabilities from our sites and thus alienate them further. Another unique characteristic of disability discrimination lies with the environment. People with disabilities rarely share their otherness with people they are involved with, such as their friends, family, and so on. They have to actively seek out a community or deal with an ill-equipped social environment. They often have to deal with pain, fatigue, and muscle weakness. To manage those, assistive technology can help, but it is expensive and therefore not accessible to everyone. Finally, people with disabilities use language in a unique way to change perception of their otherness. In our research, we were furthermore able to observe the importance of information when it comes to hiring people with disabilities, maybe in the form of disclosing a disability or legal knowledge, such as about reasonable accommodation, which we discuss further in our paper. Additionally, we have come to believe that AI ethics as a field of research has failed people with disabilities. AI in general has difficulties with considering anything that is out of norm, but even assistive technology like voice recognition is not equipped to adapt to the needs of people with disabilities, or simply not trained with all users in mind. This leads to technology that was intended to help people, but fails to help those with disabilities. In AI ethics guidelines, we rarely find mention of people with disabilities, other than as therapeutic or non-therapeutic users of AI. This sparked our interest, and we conducted a quantitative literary study of 82 AI ethics guidelines. Unsurprisingly, also these guidelines mostly fail to address people with disabilities, or even consider them as a vulnerable group worth keeping in mind. None of the analyzed guidelines have identified the unique position of disability to progress ethical principles of AI. To bridge the ethical with the legal world, and thus with our next analysis, we looked also at the conceptualization of discrimination by EU law, which we found to be consequentialist. In ethics, consequentialist theory also includes our aim, the moral obligation, to support those less advantaged within our society. AI ethics as a discipline could benefit from translating this legal understanding into an ethical principle to embed anti-discrimination in the progression of ethical AI. In the legal analysis, we take the viewpoint of EU law, which allows us to consider also the impact of the AI Act proposal. First, we ask whether automated hiring systems are discriminatory, and the answer is yes. In fact, people with disabilities have a specific right to reasonable accommodation under the Employment Equality Directive. This means that employers shall take appropriate measures, if needed, to enable a person with a disability to work for them, although within the limits of what is not disproportionately burdensome for employers. Then, we argue that this right applies not only when there is an employment relationship, but also before, namely during the hiring process. However, as we demonstrate in the technical section, existing AI systems are ill-equipped to provide reasonable accommodation, Hence, they are not only illegally discriminatory, but we argue that they can also be presumed to be discriminatory. This difference may seem a subtle one, but it's crucial because the presumption shifts the burden of proof onto the employer in an anti-discrimination lawsuit, which is a tremendous procedural advantage. Second, transitioning to data protection law, we discuss whether disability data can be processed. In principle, this is prohibited because it is personal sensitive data. However, Article 9 of GDPR provides for some exceptions. We argue that only the exception under letter B is applicable, namely for fulfilling obligations in the field of employment. That in our case is of course the obligation to provide reasonable accommodation. Nonetheless, we are not really satisfied with this result because the general prohibition on processing sensitive data is inspired by the fairness through unawareness fallacy. And that's why we recommend the implementation of the general exception under letter G for processing for reasons of public interest, such as preventing discrimination. The AI Act proposal seems to go in this direction as it enables processing of disability data for debiasing. In any case, once disability data is processed, it can be accessed by data subjects. By accessing this data, it may be possible to gather enough proof for establishing the presumption of discrimination that we mentioned before. Finally, we discuss the processing of non-personal data, such as proxies or anonymized data. They fall outside the scope of GDPR, so they can be processed. In practice, the information on one's disabilities can be extracted from proxy data and then can therefore be a source of algorithmic bias. To conclude, we compare the relevant framework to two other instruments. First, the proposed directive on platform work aims to introduce a wider right to explanation compared to the GDPR, and we think that this should be extended to other contexts, including automated hiring. By contrast, the New York bill on automated hiring is not really far-reaching at first glance, and we believe it should not be taken as a model. In conclusion, making automated hiring systems respect the rights of candidates with disabilities is challenging. Nonetheless, we aim to give some practical recommendations. First, these systems shall not be fully automated, so humans play a decisive role in the decision-making process. Second, a rigorous data protection impact assessment is necessary. Therefore, employers must implement specific measures to make sure that the system recommends reasonable accommodation or at least flags eligible candidates for future consideration. Third, it is worth mentioning that the AI Act aims to introduce further obligations, even though they are not addressed to providers that are normally the employers themselves, but a third party. Not the employers themselves, but a third party. In any case, several provisions tackle algorithmic discrimination, such as the duty of debiasing, the mandatory presence of a human supervisor, and even the obligation to register the AI system in a central database, which makes it easier for actors such as advocacy bodies to discover potentially discriminatory systems. The positive side is that the EU legislator is taking algorithmic bias very seriously. However, the negative side is that the approach is a bit naive. For instance, some provisions are based on the assumption that it's possible to have data that is literally free of error, which is not the case. Moreover, there are no legal remedies for affected people. So in our case, rejected job seekers could not sue recruiters for failure to comply with the AI Act. Now, from a technical point of view, people with disabilities are a particularly heterogeneous group. For example, someone may require more time for a test because they require assistive technology. Someone with autism spectrum disorder may be more likely to avoid eye contact during an interview, which is then seen as a lack of confidence. Or someone who has recovered from a long-term illness may have a gap in their resume. All these people could receive a worse assessment from an automated hiring system because of their disability, though for vastly different reasons. Now, for other groups, there exist technical tools to adjust data or algorithms such that discrimination is reduced. However, these tools rely on simplistic assumptions that view bias as something that affects all members of a protected group in a homogeneous way. Clearly, such assumptions are especially misplaced when it comes to people with disabilities. We should therefore carefully explore technical solutions to handle this heterogeneity. For example, we can try to build a technical model of disability by focusing on the limitations that may result from disability. After all, to provide reasonable accommodation, we don't really need to know why someone has a certain limitation. We mainly need to know, are there any limitations we should consider? To which extent do they matter for the assessment that we are making, and how can we accommodate them? Again, we do stress the need to be very careful here, because a poor technical model of disability could do more harm than good. Now, it is difficult to provide reasonable accommodation with an automated hiring system because every kind of limitation can have very different impacts on the assessments. We therefore need to adjust the decisions we make based on these assessments, but this is very case-specific and therefore difficult to achieve in practice. Even with a good technical model, it can also be difficult to actually carry out a proper automated assessment of an individual if they are, for example, somehow prevented from participating in the standard format of the assessment. For example, if an assessment usually contains a spoken interview, then it could be more fair to grant a deaf person the ability to participate using sign language instead of oral language. However, this should not mean they receive lower or higher scores, so there is a technical challenge in balancing these different formats. If a fair automated system can't be made, then we should decide to have a human intervene instead. This obviously can be costly, and we then have to make sure that the human is not more biased than the automated system already was. Solutions may exist to all these kind of technical obstacles, and many limitations could be addressed with some adjustments. However, we should still question how reasonable these accommodations are. The idea of reasonableness is a legal concept, but there is no clear legal threshold on which accommodations are reasonable or not. We should therefore wonder how much investment should be made, for example, into accommodating different ways of communication. How strongly should we take a specific limitation into account when assessing someone's profile? These questions are clearly difficult to answer. Now, even though reasonable accommodation is difficult to provide with an automated system, we do still see some opportunities for AI systems to be a useful source of information during the hiring process. For example, AI systems could help a human recruiter to find out which accommodations are possible for a candidate, while leaving the final decision to the human. Also, an automated system could be used to better protect the rights of people with disabilities, because these systems can be easier to audit afterwards than a human recruiter. Okay, thank you for your attention. We hope to see you at the conference.